last video today. We're going to talk about the next order of operations. 4 is statement of facts. 5 is your legal argument section. All right. And I'm not going to talk too long about this because there's not really a way to generically address this, because every brief is going to be different. Every fact scenario is going to be different. Every legal issue is going to be different. But there are 2 main ways that you can kind of set up your legal argument section. The first way, which I'm going to get out of the way quickly because I really don't like it, is to mimic what, if you're responding to a brief, if you're responding to a motion, you can mimic what the other side did and just kind of say, all right, in their first heading, they talked about this element or this issue. And so now I'm going to talk about it in the same order. And I'm just going to go argument by argument and rebut basically everything. But I don't like this. It's a good starting point maybe, but it shouldn't be your end all and be all, because for a couple of reasons. For one thing, it presumes that the opposing party knows how to assemble a brief, which is so rarely true. For another thing, it's limiting. It limits you in the arguments you can make. It doesn't allow for any creativity or creative arguments or thoughtful discussion. It's just kind of like, no, I didn't. No, he didn't. No, it's not. Nope. Nope. Sorry. Nope. That's wrong. Nope. And that doesn't do a lot for getting the court on your side. So maybe the opposing party forgot something. Maybe they didn't flesh out the issue enough, which is probably more likely to be true. Maybe more headings are needed. Maybe fewer headings are needed. Maybe you want to concede something and you want to just not address a thing. Or, I mean, I would never not address it. I would say specifically, I'm not going to argue this because it doesn't matter. Or I'd say, yeah, I'll give you this one. It doesn't, like, yeah, we can't prove that one thing, but that doesn't matter because of all this other stuff. So I wouldn't ignore arguments that they make, but I wouldn't base your whole brief on their outline and their structure. It's an okay place to start, like I said, but it shouldn't be all encompassing. The other way you can do it is kind of elemental, which is like, okay, to prove negligence, you need 4 things. You need duty, breach, causation, and harm, right? So maybe the motion isn't really about all 4 of those elements. Maybe defendant is only attacking one, or like maybe duty. But within duty, there's all these specific things that need to be broken down to determine whether there's a duty, right? Or to determine whether there's a question of fact that makes it so we should even be discussing duty. So you want to kind of like base it on the law usually. That's kind of how I do it. I break it down by elements, and then my mind just kind of works really well as far as outlines go. I like the logic of it. I like the flow and the breaking it down. Well, this can be broken down into 3 different things, and those 3 different things, the first one needs 2 elements, or, you know, there's these 2 cases that talk about that thing. So that stuff breaks down really well to me. The other thing I'm going to suggest right now is that when you're doing your briefing, this is also when you're doing your outlining, I mean, in your argument section, this is, because that's all we're talking about right now. I'm sorry if I was confusing, but we're talking just now about outlining and how to set up your legal argument section. So as I said, you can use the opposing party's brief to kind of get you started on that path. When you're outlining, this is also when you're doing your researching, right? Because you need to know what elements of different things are and what the rules are. And so while you're outlining, I'm throwing statements of law in under those outline headings, right? I'm throwing them in. Maybe I won't use them all. Maybe I'll take them out later. But through my research, I'm going to be pulling out statements of law I can then throw in. And maybe those statements of law are going to be the details of the elements, and those are going to help me create my other headings for my outline. The other thing I do is every time I write a brief, I give it a little labels. Okay, this one is about, this summary judgment opposition is on the question of duty. And maybe I do something that kind of like describes the fact scenario or something like that, that kind of like I can come back to it later. And I tag it so I can easily search it later, so I can search for it later. If it's a very interesting area of law or like something new that I'm learning, I'm going to create a little brief about it, and I'm going to put that in my little research folder on my desktop. And I'm going to have all these things ready so that when it comes time to write a brief, I've already got statements of law that I can throw in, that I can paste in. A lot of it comes from Casey, from the jury instructions. You can get a lot of great things from those. Little tidbits and statements of law that are going to help make your brief writing easier. And if you throw them in during the outlining phase, then when it's time to do your analysis, which is the next phase, you're going to be 2 steps ahead. So that's my process for outlining briefs, and think carefully and creatively about how you want to argue something. What is it about what the opposing party is saying or wants you to will say in opposition to you? What is it about that is a logical fallacy? What is it that makes it not resonate? What is it that what's the thing that kind of stands out to you as being incongruous or unjust, right? Those are the things that you want to be thinking about to help you get creative with your arguments. And those creative things, those creative insights kind of come to me a lot during the outlining process, because I'm thinking big picture about what I want to say. And this is where, if you've done the vision exercise at the beginning correctly, you're helped in narrowing and streamlining your issues, and that help you make that signpost an easy to follow path for the court to rule in your favor. All right, make it a good day.